What you're about to watch may seem like a basic civics exchange, but it quickly turns into something far more revealing about the state of constitutional understanding, and, more importantly, the willingness to defend it under pressure.
Thank you, Senator Coons.
Thank you, Chairman Grassley, and to each of you and your families, congratulations. And thank you for raising your hand to serve, and in some cases continuing to serve the public.
Thank you.
Mr. Mark, if I might, just tell me about the 22nd Amendment. What does it provide?
The 22nd Amendment, Senator, my career has mostly been in criminal prosecution. I haven't had an opportunity to use that one specifically.
Anyone able to help on the 22nd Amendment to the United States Constitution?
Senator, I believe it is the amendment that deals with a two-term limitation on
Correct.
the service of
It
the
states
president.
no person shall be elected to the office of the president more than twice. Mr. Mark, is President Trump eligible to run for president again in 2028?
Senator, without considering all the facts and looking at everything, depending on what the situation is, this to me strikes as more of a hypothetical of something that could be.
It's not a
raised.
hypothetical. Has President Trump been elected president twice?
President Trump has been certified the President of the United States 2 times.
Is he eligible to run for a third term under our Constitution?
I would have to review the
All I need to tell
wording
you
of
is
it.
the language of the constitutional amendment that makes it clear that no, he is not eligible to run for a third term. Anybody else brave enough to say that the Constitution of the United States prevents President Trump from seeking a third term? Anybody willing to apply the Constitution by its plain language in the 22nd Amendment? Nobody. All right, let's move on. Mr. Coons, what is res judicata? How does it apply?
It's a judicial doctrine that prevents a judgment that has been, in one case, applies to a, you can't go into court after a final judgment in one case and have it, and litigate the same things again.
How is that distinct from collateral estoppel, which precludes litigating the same things?
Res judicata, one involves the same party, the other involves the same things.
And what's a requirement for these two doctrines to apply?
Notice, opportunity to be heard, final judgment of a court of competent jurisdiction.
Anyone disagree? If I might, Mr. Coons, is it pronounced the same way mine is?
Yes, it
Coons?
is. Yes, Senator.
My family's name was spelled that way when we came to the country. So, you were one of 3 judges on the panel in Alexander v. Trump, where the president was suing the Pulitzer Prize Board for defamation. When did your work on that case begin? When were you assigned this case to decide?
I first learned of that case in approximately January of 2025.
Not when the briefs had been filed?
No, Senator. The way it works in our court is we are not assigned cases when the briefs are filed. Once the case is ready for disposition, the clerk randomly assigns it to the judges in the court.
And when did you first speak to Senator Scott's office about your interest in a district court seat in the Southern District of Florida?
I mean, I've had many conversations with Senator Scott's office. The one about an interest in the Southern District of Florida, I believe, was in November of 2024. I don't know the date, but it's in my Senate Judiciary questionnaire.
And when did you release the opinion ruling in President Trump's favor in this matter?
So I learned of the case in January of 2025, and the opinion was released in, I believe it was February 12th, 2025.
That's correct. So you issued an opinion where one of the litigants before you was the president and in favor of the president while you were in active conversation with the senator's office about seeking a federal judicial appointment. Is that correct?
For a position I did not, in fact, get, Senator.
How did you end up in front of me today?
It's a different position, Senator.
Did you consider recusing yourself from that particular decision?
No, and the canons that govern us in Florida, Senator, as I believe this committee has previously heard, it did not call for me to recuse myself. I did not have an interest in the litigation, and none of the basis called for recusal. And the Florida Supreme Court instructs us, the appellate judges, that we are not to recuse unless one of the bases in Canon 3 exists.
Does the Florida canons not require you to recuse if one of the parties before you has an interest that could be reasonably concluded by any common citizen to cloud your judgment on that matter?
Senator, I disagree with that characterization. I had not heard from the White House until after the opinion was final. I had only spoken.
When did you interview with the White House counsel's office?
At the end of February of 2025. I don't know the date, but I believe it's in my Senate Judiciary questionnaire.
Thank you for your testimony on that matter. Mr. Hendershot, if you would just take a minute and talk me through again how collateral estoppel and res judicata are different from each other.
So I'm not sure I can improve much on Judge Coons. I think that often res judicata today is used as sort of a catch-all term, but generally I think the difference is between claims and claims that may have not been brought but could have been brought potentially.
Right.
Collateral estoppel and res judicata is more a thing actually decided, as the Latin would suggest.
Thank you. Do you agree that judges should not be influenced by external pressure to rule in any particular way?
Yes, Senator, I do.
President Trump stated March of this year at a public event, quote, "We have rogue judges that are criminals. They're criminals, what they do to our country, the decisions they hand down and hurt our country." Is it possible for a judge's decision to be correct as a matter of fact and law, even if it differs from the president's desired outcome?
Senator, I want to tread carefully because of Canon 5 in terms of commenting on political matters. But in the abstract, yes, decisions can be corrected, and any citizen can criticize what a judge has done. That is, I think, part of the right to speak.
Thank you. Thank you all for your testimony.
Yeah. Mr.
When Senator Chris Coons asks a simple question about the 22nd Amendment, he's not fishing for a complicated legal theory. He's asking one of the most straightforward questions in American constitutional law. How many terms can a president serve? This is something most Americans learn in school. 2 terms. That's it. It's written plainly, clearly, and without ambiguity. So when a judicial nominee hesitates, or worse, claims they need to review the issue, it immediately raises a red flag. Because this isn't about memory, it's about judgment. These are individuals seeking lifetime appointments to the federal bench, positions where they will be responsible for interpreting the Constitution in some of the most consequential cases imaginable. And yet, when asked to apply the plain language of the Constitution to a real-world scenario, whether a president who has already been elected twice can run again, they struggle to give a direct answer. That moment matters. It tells you that the hesitation isn't legal, it's political. Coons makes that clear when he pushes back and says, this isn't hypothetical. It's grounded in fact. Donald Trump has already been elected president twice. The Constitution is explicit. There's no gray area here. And yet, no one on that panel is willing to simply say it out loud. Think about what that implies. If a nominee cannot affirm something this basic, what happens when they're faced with a case where the Constitution is under real pressure? Where executive power is being tested? Where the answer isn't politically convenient? This is exactly why these hearings exist. They're not just about qualifications or resumes. They're about independence, the ability to stand on the law, even when it might be uncomfortable. Because a judge's job is not to protect any president, any party, or any political movement. It's to uphold the Constitution, period. And the exchange doesn't stop there. As Coons moves into questions about judicial conduct and past rulings, another layer emerges: accountability. He raises concerns about a nominee ruling in favor of Trump while simultaneously pursuing a federal appointment. That's not a minor detail. It goes directly to the issue of impartiality. Judges are expected to avoid not just actual bias, but even the appearance of it. So when there's a timeline that suggests overlapping interests, deciding a case involving a powerful political figure while seeking advancement within the same political ecosystem, it's reasonable to ask tough questions. Not because anyone is assuming wrongdoing, but because public trust in the judiciary depends on confidence that decisions are made independently. And then there's the broader context Coons touches on, the increasing rhetoric attacking judges. When public figures label judges as rogue or criminal simply because they disagree with a ruling, it puts pressure on the entire judicial system. It tests whether judges, and those who aspire to be judges, are willing to stand firm in the face of that pressure. So when Coons asks whether a judge can be right even when the president disagrees, he's really asking something deeper. Will you follow the law even when it's inconvenient? That's the through line of this entire exchange. From the basic question about term limits to the more complex questions about judicial ethics and independence, what's being tested here isn't just legal knowledge, it's integrity. Because at the end of the day, the Constitution doesn't enforce itself. It relies on people, judges especially, to apply it honestly, consistently, and without fear or favor. Watch closely how these nominees respond. Not just what they say, but what they avoid saying. Because in moments like this, silence and hesitation can speak just as loudly as words. If you care about protecting democratic norms, defending the Constitution, and ensuring that the judiciary remains independent from political pressure, stay engaged. Like, subscribe, and share your thoughts, because these are the moments that shape the future of the rule of law.